in this issue, in line with the Sessions decisions by this court, that would render its probative value.
Your 403 argument isn't this sort of evidence could never come in under 403. It's that it would have to be assessed on a case-by-case basis, and in this particular case, it doesn't come in?
Yes, Your Honor, that's exactly it. And the example would be if I'm on my porch and I know my neighbor across the street's moving in, he's a parolee, I do some research on him, I find out he's actually killed a neighbor and done time for voluntary manslaughter, he's a child molester, he's a member of the Aryan Brotherhood. I don't want him in my neighborhood, so I walk over to his house and to his lawn with a gun. I know exactly how he's going to react. I tell him his kind isn't welcome in my neighborhood. He balls up, I say he was reaching for something, and I shoot him. Now, when I'm charged and the police come and get me, I tell them, listen, this guy's done all these terrible things. I read about it on the internet, and that's why I did it. I go to trial, and I claim self-defense.
Well, counsel, let me ask you this about your unfair prejudice argument. I mean, there was quite a bit of evidence that came in about Dimmons and the other things that he did. I mean, he said things like, I'm chain gang bound, intimating that, he was going back to prison.
His shower shoes.
Yeah, his shower shoes, all those types of things. And all the threats, the prior difficulties. I mean, the jury got a sense that he wasn't a really great guy, and so I mean, the fact that he shot at someone in some unknown situation, I mean, is that really unfairly prejudicial in this case when there was all this other evidence that he wasn't that great anyway?
Well, I think, and I was thinking your argument was going in the other direction, that the jury heard lots in terms of the harmless error, that they heard lots about his evidence, about his past. But it still creates the issue where the jury is going to make a decision that he needed killing based upon and use that evidence for propensity as opposed to the state of mind. Also,
I would get that argument if he was like all the evidence was that, he was a churchgoer and all this stuff, and then this one incident he shot at somebody. But I mean, there was all this other stuff that he had done, that wasn't great.
But, and kind of going towards the Texas case too, they touched on it as the similarities. The event, we had very limited information in the record about it, but it involved the victim's girlfriend in a hotel room and another man. And if this situation is so far afield from that, did the defendant really have anything to fear? And again, overriding this whole argument is the fact that the defendant went to the victim. He sought him out for this encounter, and he instigated it, he pushed it, and he used it as an excuse to kill him, and that's not self-defense. I don't know if the court has any questions as to the last issue.
There don't seem to be other questions, counsel.
All right. Well, if that is the case, I will sit down. Thank you very much for listening to me.
Thank you, counsel. Mr. Anderson, 221.
Thank you, Your Honor. I just very briefly, first in response to the Sessions case that Mr. Adupe brought up, I did cite the Johnson case in my reply brief, and I would point out that the self-defense at issue in Johnson came up in the context of ineffective assistance of counsel, which of course required the defendant to prove that it was more likely that it would change the result of the trial. So that's a higher standard for the defendant, and even there, the court said that he passed the Strickland test, and so it's going to have to be a new trial. The Sessions case was just the regular harmless error where the burden was on the state. So again, I think the fact that this Johnson is there sort of shows just how expansive that this court treats the juror's right to decide what is and isn't a reasonable force. Secondly, in the argument here a few moments ago, we heard the state just concede that there was in fact slight evidence of self-defense, which meant that the jury charge was proper. In their brief on page 35, they said that in fact the charge was improper, but I think they have appropriately conceded that it was proper, and to my mind that makes it now relevant, and so then we're stuck with sort of 403. 403 says that the danger of unfair prejudice has to be substantially outweighed, that the relevance has to be substantially outweighed by the risk of unfair prejudice. And of course, the more important a piece of evidence is to the defense, the higher the prejudice you have to have over here. And the only defense in this case was self-defense. And so all of the evidence that's relevant to self-defense is Mr. Tarver's only real hope. And given how important the evidence is to Mr. Tarver,
Although the probative value that we assess under 403 is the marginal probative value of that piece of evidence in the context of everything else that's already come in, right?
right, and so, but here, it's the fact that he shot someone who ultimately was not armed. I think it's very relevant that Mr. Tarver was aware that he had actually shot someone in the very recent past, and so that might suggest that he thought that he had a gun after all. And so with that, I would ask you to remand for a new trial. Thank you, Your Honors.
Thank you, counsel, for the final argument. We'll have your decision as soon as possible. With that, we're going to take about a 10-minute recess, and we'll come back for the final case.
All right.
All rise. You may be seated.
Madam Clerk, if you'll please call the next final case for the day, please.
S24A0448, Jennifer Rosenbaum versus the state. Ashley Merchant for appellant, Samuel D'Entremont for appellee.
Good morning, counsel. Ms. Merchant, you may proceed when you're ready.
Good morning. Thank you so much. May it please the court. Ashley Merchant on behalf of my co-counsel, Brian Steele, who wishes very much he could be here today, and representing Jennifer Rosenbaum. I want to start with what the state argued back in 2017. On June 23rd, 2017, the state said, if Corinne Moll continues to represent both defendants in this case, Jennifer and Joseph, there's no doubt that if they get convicted, there's going to be an ineffective assistance of counsel claim and argument made. There's no doubt, if you look at the entirety of just looking at the base facts, the type of charges, and the dual representation, that if this case, if there's a conviction and it goes up, whether there's a waiver or not, it will be reversed. And that's what we're here arguing today. This is exactly what happened. Ms. Moll was permitted in error to continue to represent both Joseph and Jennifer Rosenbaum. It resulted in an actual conflict, and it infected the entire trial. It infected her representation, and it infected the result. So I would ask, has anything changed the state's position besides the conviction in this case? And they actually addressed that Joseph's case is pending in the Court of Appeals. So that's not pending before this court because he was not convicted of murder like my client Jennifer was. Joseph was convicted of second degree, so his case is actually pending right now in the Court of Appeals. But the state addressed that question in their briefing in that case and said, they attempted to answer it. They admitted the only thing that had changed was there was a trial and a conviction, and we now had Ms. Moll's testimony. But the thing about Ms. Moll's testimony at the motion for new trial is it actually supports our arguments here. It does the opposite of what the state argued. It strengthens what the state knew back in 2017 when they asked the trial court to disqualify Ms. Moll from representing both Jennifer and Joseph. The set of facts in this case demand separate counsel. This court, if there's ever a set of facts that demand separate counsel, it's a case like this. This court decided a case with similar, and I use the word similar in quotes, facts on a different issue, Bell versus State. And so I just want to draw the corollary to that. Imagine, and Justice Ellington, you wrote that opinion, imagine one lawyer representing Courtney Bell and Christopher McNabb in that case. No one could do that.
Isn't there pretty extensive evidence here about consultation with independent counsel and waiving?
No, Justice Warren, there's actually, the record does not actually have any proof that there was independent counsel other than myself, who was consulted in 2019. So that's important to note. So in 2017, the first indictment in this case was for malice murder. Both defendants were charged with felony murder and malice murder. Ms. Moll was then challenged for the conflict. Then the state re-indicted the case. So they charged Joseph with second degree with a criminal negligence theory. They charged Jennifer with malice, okay? So at that point, the conflict issue had already been litigated. The court said, Ms. Moll, you're still on. There was no additional waiver done at that point. So the waiver had already happened. So, and it's important to note, the waiver's not actually in the record here. So we don't even have a record we don't even have a waiver, an actual written waiver in this case. But we did have
Is the waiver disputed?
Whether or not there is a waiver is not really disputed because we talked about it, and we actually had an expert that talked about it. But but we don't have it to look at here. But we do have some testimony, and so there was an expert called by the defense, Mr. Chandler, and he actually addressed your Honor's question. What he talked about was with the 2017 charge, the waiver was an issue. With the new charges, though, when Joseph was charged with criminal negligence for leaving Laila in Jennifer's care, it became an unwaiverable conflict. So at that point, what the law says is you can waive certain conflicts, but there's certain conflicts that a waiver doesn't matter. So even if we're not arguing that a waiver never happened. I mean, we're not blind to the fact.
Can you explain why that is unwaivable?
Yes, definitely. So, and I would just cite to Mr. Chandler's testimony. He explained that when you're charged with murder, the conflict could be waived under 1.7. But what he said was because Joseph is now charged with this second degree because he's charged with criminal negligence, it can't any longer be waived. And that's because it's the factual issues. It's an inherent conflict. It's a conflict because Joseph, the state's theory was Joseph should not have left Laila in Jennifer's care because he knew she was violent. That's the state's argument. And because he did that, and Jennifer ultimately, in the state's view, killed Laila, that's why he was criminally negligent. Because those are necessarily pitted against each other. Those claims are necessarily against, Jennifer and Joseph.
Help me understand why they're necessarily pitted against one another if the theory of defense is absolute innocence.
Well, that's an interesting question, because talking about the theory of defense, Ms. Mull actually used a theory of defense of accident. That was her theory.
I understand, but you say that they are necessarily, and
Right.
so the point I'm trying to get at is explain to me why they are necessarily, not what was here. If both defendants' theory of defense is absolute innocence, what the state has charged did not happen with respect to either of us, why would the charge itself create an absolute unwaivable conflict?
It's not necessarily the charge, the actual name of the charge, but what's charged in the indictment.
Yeah, I understand. Okay, the charges here.
Right.
Why, without respect to what happened in this case, because you're making the claim that it's unwaivable.
Right.
Why is it that the charges here, there's no set of facts under which a lawyer could represent both?
Because the liability that the state alleged for Joseph was that he was guilty for leaving, and you actually heard a case similar to that earlier today. He was guilty just by leaving the child with Laila. So his set of facts is, I'm guilty because she's a bad person.
Why is that necessarily inconsistent with her accident defense?
Well, actually, the biggest reason that it's inconsistent is the medical examiner's testimony. So the medical examiner, the Henry County medical examiner, testified at trial that the fatal blow occurred an hour before the death actually occurred.
But that's saying the accident defense wasn't very good.
Besides not being very good, so there were a couple different options for defenses. There were different things that Ms. Mull could.
But if accident wasn't an unreasonable defense.
Right.
And that was the defense that was pursued, why is accident sort of necessarily incompatible with the defense of the other defendant?
Well, you can take Ms. Mull's testimony herself. She thought accident was a ridiculous defense. She thought that it was, her statement, and I have it somewhere, she specifically said that she thought it was ridiculous.
Because why? Ridiculous because?
Because of the evidence, because it didn't really fit with the evidence. Mostly the medical examiner's testimony, because the medical examiner testified that the fatal blow happened before the child was in Jennifer's care, and that likely what Jennifer saw that she thought was choking was actually a fatal seizure. So her saying that it was an accident.
Well, but saying that it wasn't well supported by the evidence
Right.
isn't enough to show that it was a ridiculous defense, because there are cases where there just isn't a good defense. And so you can have a bad defense still be the best one that's available.
Right. There was definitely much better defenses in this case, though. But to answer your question, it's Ms. Mull's testimony. She specifically said, and this was her quote, that this defense was outrageous and ridiculous, but that she had to put it up because it's what Jennifer told the police. But to answer your question, I think it's important to look at how you could have defended it without, and what the evidence actually supports as a good defense for Jennifer.
Are we still talking about the conflict, or are we moving over into justification?
No, we're just definitely talking about the conflict, and I did not plan on arguing much about the justification. I think that's a very discrete issue. I'm happy to talk about it.
But isn't the fact that Jennifer, in fact, did tell the police that it was an accident, I mean, that is a really relevant point that does, to some extent, kind of box you in. I mean, creative lawyers can get past lots of things.
It must inform your strategy.
It must inform your strategy, but let's just follow me down this path for a second. So Jennifer says it's an accident. The medical examiner testified it could have looked like an accident. It looked like a seizure. She thought the child was choking. So Jennifer has 2 children at this point. She is off with the older child. Laila is eating. She says she thinks Laila is choking. The medical examiner says this fatal seizure looked a lot like choking. There's no evidence that she was choking. There's no food in her mouth. There's nothing, medical. But Jennifer doesn't know that. All Jennifer knows is she's taking care of Millie. Layla looks like she's choking, potentially a fatal seizure, but Jennifer doesn't know that. Jennifer doesn't know what happened when Joseph was there. She has no idea. She has no idea what happened before she came home.
So are you saying that the theory of the defense should have been it wasn't even accident, it was just natural?
No, for Jennifer, not that it was natural, no. I think the theory, if I was defending it and I had to choose at this point, I think based on the medical examiner's testimony that Joseph was the one.
I guess I'm missing
Joseph.
how this links into the conflict point.
It links into the conflict point because it talks about how Miss Mull was actually conflicted.
You think the better argument was to point the finger at Joseph?
100%. You've got a child that you have concrete medical evidence suffered a non-accidental blow.
So when a couple of people who are close to each other don't want to point the finger at each other, don't they have the right to decide whether they want their defense to be one of not pointing the finger to at each other?
As long as they have separate counsel that is advising them of that, yes. But they did not. And so if they had two lawyers advising them, one lawyer sits down with Jennifer, one lawyer sits down with Joseph, goes over all the potential defenses, and they both decide independently with a lawyer that is not divided, a lawyer that is not conflicted, they decide we don't want to point the finger and this is the defense we want to do, then that's fine. But that's not what we have here.
Well, that's like the best case scenario, right? Often things don't work the way we want them to. Is there any other situation where it would have also been fine without can they make that decision themselves, knowing that there could be a conflict?
As long as they were fully apprised. The problem is they were not here. So
Well, not only fully apprised, but fully apprised by separate lawyers.
right, fully apprised by separate lawyers. And this is not a big ask. This is what the Constitution requires. They require a conflict-free counsel. It's not like we're asking for 100 lawyers to come in.
Is your counsel across the way going to agree with the facts you've set out about whether independent counsel was consulted, or is there a disagreement about that?
There's a disagreement, and I'm glad you brought that up because that was one of the things I wanted to make sure I had time to address. I believe that they do have a question about that, and so I just want to talk about that for a second. So the state believes that, and I'm not quite sure, I'll let them say exactly what they think, but whether or not there was consultation with independent counsel. What the facts show that there was I was the only person. So there's no extra lawyer anywhere. I'm the only other person that was consulted. And I was consulted in 2019. That's what the facts show. In May of 2019, I had an opinion that was relevant, and I was consulted about that case. That's all in the facts, so I'm not testifying in my place on that. The state argues extensively in their brief that there was another attorney somehow, independent counsel. But that's not what the evidence actually shows. The evidence actually shows, if you look at Ms. Mull's testimony and you look at what was actually admitted, she doesn't even think that there was someone else consulted.
So explain to me why actually consulting with independent counsel is absolutely necessary to avoid a conflict. My read of 1.7b is that they have to have the opportunity. But being offered the opportunity is very different from actually consulting.
As long as they're apprised. So yes, you could get there, but only if Ms. Mull had actually properly apprised them. And that has to happen on the record. There's a lot of different things that didn't happen in this case.
Does it have to happen on the record?
Well, there's a dissent opinion that says it should happen on the record. In this case, I would submit that it needs to happen on the record. Okay. It definitely, in my opinion, it should.
But there's not a legal authority you can cite that says it must happen on the record?
No,
okay.
There is not.
I agree it is always better for things that are important to happen on the record.
Right.
That doesn't make it reversible error for it not to.
Not that, but that's not really the crux of our issue, our argument, whether or not this issue was waived on the record. It's whether or not they were advised. And we don't have any evidence that they were advised of any of this information. All we have is Ms. Mull saying, I said there could be a potential conflict because the state brought it up. You guys can go look at another lawyer if you want. But what the evidence shows is as soon as they called me about a different issue, she said, I'm going to quit if you call another lawyer. So the only time that they actually
And that's disputed as well, correct? That characterization?
No, that's not. That's actually in the record. That is, let's see. The state put in one email and we put in one email, but that's actually in the record. her email is in the record, and I will tell you exactly where. It is at page 258 of the record, but it's an email where as soon as, this is in May 2019, as soon as she had reached out to my office about the appeal, Ms. Mole said, if you're going to hire someone else for the appeal, you need to hire someone else for the trial as well. I will not be second guessed. And then she was questioned extensively about that and said that's true. And her quote.
And why would that, why does that violate their rights?
It's a big issue because the trial happened in August of 2019. This is in May, so this is 2-3 months before. If you dare to talk to another lawyer about an issue, I quit. They didn't have any money because at that point they had already filed for indigency status.
Do trials ever get extended when counsel changes?
It did not in this case. It actually, in the record, they had asked for that, and it had been denied. There was a very contentious hearing, it's in the record, where the judge said, I am not continuing this another time. And he thought that this, they wanted to be able to save up more money, so what the record shows is they wanted to save up more money to get another expert. Dr. Sperry was their expert. Some things happened with him. He was not going to be a great trial witness anymore because he had some issues of his own. So they wanted a new expert, but they ran out of money. So they were stuck with Corinne Mole, and they were stuck with Dr. Sperry. They went to the court and said, we need money. Court said no. They said, well, we need a continuance then to get money to get a new expert. Court said, no, you're going to trial.
That's different than asking for a continuance because your counsel's changed. That's a separate issue.
Right. They had not asked because their counsel changed, but the court made very clear in that record, in that hearing, we are not continuing this case again. This train is moving forward.
Can I ask a different question? And it may be a bit unfair, and so if you're not able to answer it,
Okay.
that's okay. The Sixth Amendment guarantees a right of conflict-free counsel.
Yes.
Why is the conflict that is assessed under the Sixth Amendment determined by state rules of professional conduct?
Well, I think there's a constitutional argument as well. I mean, I think everything is the backbone of it is the Constitution, whether or not there's a constitutional right to have conflict-free counsel. We look at it through the lens of the rules of professional responsibility, but the reason I couldn't answer some of your questions earlier, absolute, is because it's a continuum. It's one of those things we know it when we see it sort of situation.
So the fact that a rule of professional conduct may say something is okay or not okay isn't the end of the question of is it a conflict for purposes of the Sixth Amendment?
100%. It's a very, and that's one of the reasons you haven't heard me cite much law, because this is a factual dispute. This is an issue where the facts are what matters. And I think that's why we don't have a bright line rule that says you can never represent two people at one time. We can't have that bright line rule. That doesn't make sense. It's not applicable in all cases. But in a case like this, it definitely is.
So what is that rule that you would like, you think that should control? How would we articulate that rule so that folks in the future aren't left with, we'll know it when we see it, when we show up?
Well, I think we already have it, Judge. I think we have that rule, and I just think it wasn't followed here. We've got the rule that says that if there's an actual conflict, does it affect the representation? Not does it affect the outcome, but does it affect the representation?
That's sort of presuming the outcome, because the whole question is what's the actual conflict? Like,
Right.
what is the rule to determine whether there's an actual conflict?
Right, whether there's an actual conflict. So in this case, we would argue that there is an actual conflict. But even if there wasn't an actual conflict, there's still enough evidence.
Right, okay,
of
but-
prejudice.
Is the presence of arguably antagonistic defenses enough to trigger this rule?
That's what the law says when there's an actual conflict. But what the law says is it has to be something.
Counsel, I mean, you're answering what is an actual conflict by saying it's an actual conflict when there's an actual conflict. So we do need contours on how to define that, because it can't be that everything is just case by case. If you're looking for a real rule.
And I have
And that's my question, is whenever, you said that we can't have a rule that says you can't represent two or more defendants.
Mm-hmm.
But if what you've just answered me is right, that if there is an arguable way that they could have antagonistic defenses, then there's a conflict, then the rule is you can't ever, because any capable advocate could conceive of some way that you could have antagonistic defenses.
Well, but the law says it can't just be some fantastical way. You can't just come up with some non-palpable, and I think is the term.
So what is it that what is it?
What the rule says now is if it significantly affected counsel's performance. So what the rule is counsel's performance. Yes, it did here. Definitely did
The
here.
conflict, what's the evidence that the conflict that counsel observed affected the defense of either of the clients?
There's three things, and they're all based in case law. The actual conflict existed because trial counsel was held back from raising a potentially meritorious issue because of the conflict.
What did she say? What was her testimony that she did not advance based on the conflict?
She did not advance the issue that Joseph did this. She testified about 10 different times about that.
Well, wasn't that based in part on the party's unified front defense?
Yes, because she supported that
So
defense.
you were judging this in hindsight that it was a better argument. And
Well-
that better argument would have then therefore created a conflict.
But that's why they are supposed to be informed of that. You know, a better argument, as long as if Jennifer and Joseph had been told, these are all the potential arguments, Jennifer, the Emmy puts the time of the fatal blow when you weren't there. It puts it when Joseph was there. And the Emmy supports that you probably had no idea, and your choking actually makes sense because it was a fatal seizure and it looked like choking. If Jennifer had been told all of that, I think she would have had a very different opinion. She was not apprised of all those things. And that's the problem. That's the problem here. You've got a conflict, and you've got a lawyer just saying, trust me, we don't have a conflict. Oh, sorry. Thank you.
Thank you, counsel. Mr. Dumontront, good morning. Welcome.
Mr. Chief Justice, members of the court, it is truly a pleasure to come before you again. I hope I feel the same way when I sit down. I would actually like to start with one of Justice Peterson's last questions, and I hate to launch directly into areas that we didn't strictly cover in the briefs, but we developed this issue more fully in Joseph Rosenbaum's case in the Court of Appeals, and at the end of this, if you need a supplemental brief, we're happy to provide one because we have done it already. The question was, why does the Georgia Rules of Professional Conduct have some relevance to a Sixth Amendment determination? And I would propose this answer, which is drawing from case law, but is something that this court would have to find. It does have a bearing if the conflict is evaluated in a pretrial posture. The one case that does import the Georgia Rules of Professional Conduct into a joint representation situation is Registe v. State from 2010. That was a pretrial challenge to, if I recall correctly, a refusal to take a counsel off a case when there was a joint representation. I may have that backwards. But the important thing is that it was pretrial. And the court invoked Rule 1.7 to look at what counsel's obligations to their clients were when it came to joint representation. The reason that matters, and the reason why we have to look at ethical obligations of counsel and the duty they owe to their client, is because in a pretrial context, all of these things are predictive. We're effectively looking into the fog of what might happen and trying to figure out whether there's a potential for conflict that'll
And when
mature.
you say predictive, do you also mean prophylactic?
Yes.
Meaning,
I
you know,
could say-
you can make choices before a trial happens to guard against the possibility of certain rights being infringed.
Yes.
Whereas once you're there, you're there.
I fully agree with that. That's why the state had some initial concerns and did bring this up in 2017. Again, trying to look into that proverbial crystal ball about what this trial was going to look like 2 years later. The picture is entirely different post-trial. Post-trial, we have a record. We have the record of the trial showing what actually happened, showing what defenses were raised. And beyond that, we have the record of the post-conviction litigation, explaining what the conversations were, what the strategic considerations were.
I want to get to those facts, but do you have a view on whether the rules of professional conduct require things that the Sixth Amendment does not require?
I think that it is, like many things in this case, a separate but parallel consideration. The Sixth Amendment, under the case law that's been developed federally and in Georgia since the 80s, asks two questions. Was there an actual conflict, which
And
is defined...
It asks those questions for post-trial cases.
That's exactly right, and that's the difference. That's why the Registe rule would control this, and I would be happy to talk all day about the professional rules if this were a pretrial issue. But post-trial, you have two questions. Was there an actual conflict, which is a conflict that affected the representation in a material way? And the second question is, was that effect adverse to one of the clients?
To what extent can was there an actual conflict question be informed by assessing the rules of professional conduct?
I would argue it's actually two separate things. I think that anything can inform anything else. But when you're looking at the ethical rules, what you're looking at is counsel's obligation for a client, and it actually has a completely separate remedy, right? The remedy to that is a bar complaint or professional sanctions. The Sixth Amendment, on the other hand, is a much more objective standard, and that fits a forensic analysis of a record like we have after trial. There's no prediction involved there. So instead of assessing what those duties might be and how they would affect potential conflicts that might mature into something, you're looking and saying, was there actually a conflict here? So the factors that are discussed in the professional rules are common sense things to think about when it comes to an attorney's obligations.
They're not just common sense, because if you don't follow them, you're going to get that bar complaint.
Absolutely.
So it's not just like, hey, let's pay attention,
And
it's not
maybe
consequence-free.
And maybe I was too glib about that, Justice Warren. What I mean is, they are the same sort of factors that you should logically consider when you're assessing whether a conflict exists, but they're not controlling. They're not an exhaustive list.
They're not controlling as to the ultimate constitutional issue.
That's correct, yes.
What's
So-
your view of what happened here as far as waiver, consent, being apprised of potential conflicts?
So I think first, it's important to realize that asking whether there was a valid waiver is really step two of the analysis. The court really doesn't have to get there unless they find that there is an actual conflict, and the state's position is there isn't. But let's assume there was. Then you have to assess whether that waiver is valid. I would submit that because this was a post-trial appeal, because nobody raised this issue until after everything played out and they got the result they got, that you have to approach that from a more objective way than you would if you're looking at the Rule 1.7 factors. So you have to look at whether there was a waiver and whether that waiver was valid. And of course, we do have some case law talking about what best practices might be. As we discussed, things should be put on the record. And in this case, frankly, Judge Amaro did have the conversation, but he did it through Ms. Mull, not directly with the clients.
And when we're talking waiver, because what we're talking about really is the waiver of a constitutional right, it's the due process standard for knowing involuntary waiver rather than whatever the bar rules say about how you waive conflicts, right?
Again, that is a difference, yes. And so when you're looking at whether that waiver was valid, there's some guidance as to what the explicit things that have to be discussed are. All of those are present in this case. They're just present through a discussion with Ms. Mull. And
So, I mean, I take it that there is some significant disagreement between the sides. As clinically as you can you explain to me what you believe is in this record factually supported by evidence?
but for the waiver,
Yes.
yes.
Well, and just what they were advised of?
In general,
and-
yes.
Yeah.
And if you don't mind, I'm going to refer to some additional materials. So we know from unrebutted testimony from Ms. Mull at the motion for new trial hearing, which again was not countered in any way, that the topic of joint representation came up very early in the case. It was in the very first meetings because Jennifer and Joseph Rosenbaum always wanted to present a united front. As part of those initial discussions, the testimony was that Ms. Mull advised them to talk to independent counsel and that they at least told her they had done so. And there is nothing in the record that says they didn't do that. Then, as things progressed, the state filed its motion in 2017.
So is it your best understanding that when your opposing counsel says there's no evidence that they consulted with independent counsel, that's not necessarily inaccurate, but it's also true that there's evidence that they represented that they did?
The only evidence in the record is that they did consult with independent counsel. You have that
What's
in...
that evidence?
So you have that initial discussion that Ms. Mull discussed. You have the written waivers that were filed as exhibits, and whether those waivers complied with Rule 1.7 was a topic of discussion at the motion for new trial hearing. Nonetheless, they are there. And
So you're
part
saying
of
the
that...
waiver is the evidence that they, I think it's a little tough to say the waiver is the evidence they consulted with outside counsel. It's more like, so far all I've heard is that they've represented that they did.
And to be frank, all we have is that they represented that they had done so. I believe, and I believe the law supports, that that's all that's required. There is evidence in the record, it has been unrebutted, that counsel was brought in for this. But that's also only one of many factors that you actually have to look at if you're
To what
determining whether
extent
a
is it
waiver is valid.
relevant to consider the legal education that Ms. Rosenbaum has received?
I do think that it is...
That may be, and there may be a different answer in Joseph's case
Absolutely.
than in Jennifer's.
Well, and as much as they're conflated, we're here for Jennifer today. So to that point, she was a third-year law student at the time all of this happened. She had very high marks in law school, although Don't take my word that that's in the record. But she was a third-year law student, and so she was a more legally sophisticated client. Ms. Mull's testimony is that she was constantly bringing ideas and potential issues and things to her attention. In fact, in Joseph's case, that's alleged as one of the ways that Mull was ineffective, is that she kept getting distracted so much by what Jennifer was telling her. We'll address that separately. But that was an absolute fact that you have to consider. This was a legally sophisticated client.
And perhaps, I mean, at a more general level, just participated in her own defense.
Very much so, intimately, yes. And so I think you have to factor all of that in. And there's no evidence in the record to indicate that they did not go into this with their eyes wide open. Everything that you hear from Ms. Mull, everything that's represented in the written filings, is that both of these parties wanted this to the exclusion of anything else. And the question that this case really seeks to answer is, where does that desire take a back seat to the Sixth Amendment?
Let me go back, and I know I've asked you this, so it's probably a rehash. Is there any dispute that Ms. Mull advised both defendants? I mean, so two questions. One is there any dispute that she had that conversation? And if there's no dispute, is then the question just how full of a conversation did she have?
The second is much closer to the question that you need to ask, because in my view, the record is very clear that she did advise them. And
that's based on her motion for new trial testimony?
It's based on her motion for new trial testimony. I didn't look much at the original waiver story, I can tell you that today. I believe the original waiver said they had consulted with independent counsel. The letters that they wrote subsequently, and this is entirely my fault, the letters themselves are not in the record, but there's extensive discussion with them with a defense expert. Those explicitly did say, I have consulted with independent counsel. And the testimony is that Ms. Mull did not write those letters for the Rosenbaums, that each of them presented those letters to her independently after separate conversations, and in those letters, they said they had consulted with independent counsel. But again, that's only one of several factors of whether a waiver is valid. And honestly, the state's position is you don't need to reach the question of whether the waiver is valid, because there was no actual conflict in this case at all, now that you look back at the actual record. And the crux of that goes to Justice Bethel's question earlier on in the argument about whether the defenses were necessarily mutually exclusive or antagonistic. They weren't. They were separate but parallel. To put it in plain English, Jennifer traveled the path of accident from the beginning to the end. Joseph traveled the path of ignorance. His entire defense was that he had no idea any of this stuff was going on either before or after the child's death. Those are not mutually exclusive, and you can assert a defense of accident without forging any kind of connection to Joseph's defense of ignorance. So you cannot say that the choices that she made with regard to Jennifer affected Joseph or vice versa, because you're trying to make a connection between two separate things that never touch each other. Ignorance and accident are two totally separate types of defense. So to the extent that there are specific allegations of things that Ms. Mull could have done that would have benefited Jennifer, objecting to testimony, some of which was non-responsive testimony that might have come out at trial, the choice to not pursue a defensive alibi when there is a legitimate dispute in the evidence about what that alibi might have been, and Jennifer had already made statements saying that she was the one who performed the acts that caused the child's injury. Whether that was a valuable strategic choice, none of those things actually adversely affected Ms. Mull's representation of Jennifer. I know we dispute that, but the facts remain they didn't. If anything, they hurt both clients equally. I mean, the counselor's discussion that both of them talked about killing the child, that was both of them. It wasn't Jennifer about browbeat Joseph into agreeing to this idea. They were having a conversation, and again, that was non-responsive testimony. So we're several layers deep into some strategic thinking. So I would submit that there was no actual conflict, and even though the question of the professional rules and waiver is an interesting one, I don't know that the court actually has to reach it to affirm the convictions here.
So do you dispute the description of the seizure potentially being a result of a head trauma that potentially was outside of the timeline when she was home?
I don't dispute that there was a potential for it, which opens the avenue to making that argument, but I don't know that it's an argument that tracked much of the other evidence. There was some dispute about that evidence. There was also some dispute about whether that trauma would have been the thing that actually killed her rather than a contributing factor.
Was there any evidence in the record as to the cause of that trauma?
Well, you have Jennifer's own statement that she leaned the child up against a sink and hit her in the back as a life-saving
To the
attempt.
extent somebody believed that there was a seizure that was a result of trauma, was there any evidence as to what preceding the moment of this,
Sure.
supposed resuscitation effort, was there any evidence about what the cause of that trauma was?
To my mind, no. There was a discussion that it could have occurred up to an hour before, but that was also a very hypothetical discussion. It wasn't concrete testimony that it did occur an hour before. That was just a possibility.
No, I understand. I'm just trying to get it, when we talk about actual conflict,
Yes.
I'm just, okay.
And,
No,
and
I-
when we talk about reasonable doubt, you don't have to have concrete, crystal clear proof that it 100% happened when she wasn't there.
Correct.
You just have to have enough to create a reasonable doubt.
That's
right?
exactly right, which makes it a tactical decision as to whether or not I'm going to deviate from the course of total innocence that it met, in looking at Joseph, not Jennifer, deviate from the course of total innocence that I've maintained up at this point, change horses in midstream, 2 or 3 weeks into trial, and now assert this idea that it was Joseph and not Jennifer that might have caused that. That is strategic thinking, that is strategic considerations, and Ms. Mull testified that she didn't want to pursue that, again, because it was inconsistent with the defenses they made all the way through this case. And also, because of the disputes in the evidence, and because neither of the Rosenbaums was willing to point the finger at each other, there really wouldn't have been anything to support that aside from speculation. To the extent that we are looking back at whether there was an adverse effect on the representation, I don't believe that gets us there. So with that, again, this trial is full of several things that go down separate but parallel paths, and that also addresses the question of justification versus accident. I do want to spend just a moment on that, although I agree that the conflict is the primary thing we're talking about today. The idea that Ms. Mull was ineffective for failing to request a jury charge on justification, which is what this argument actually is, requires 3 conclusions from the court. First, that accident was not applicable in this situation at all, leaving justification as the sole defense that could reasonably be pursued. Second, if it was the sole defense,
Why does it have to mean accident and apply as, excuse me, as opposed to being an alternative defense?
because in the context of ineffective assistance, the entire hook of the deficient performance argument is that a trial court is required to charge on the sole defense. And the assertion that Ms. Rosenbaum is raising is that justification was her sole defense, and thus Ms. Mull was ineffective not to request that jury instruction. Our position is it wasn't the sole defense. They could have argued it. But the very questions that the court was asking of Ms. Merchant earlier illustrate, and her responses even, illustrate that there were different options that could have been pursued as defense. This isn't a sole defense situation.
Can you briefly touch on whether justification legally could have fit the facts of this case? This version of justification.
So even, that's actually an interesting question, because the type of justification that's being argued is based on a person's need to render medical care. There's not actually any case law that I've been able to find saying that that would apply to justify the actions in this case. That it is the catch-all provision of the criminal justification statute, which then references a primarily civil statute talking about rendering medical care, I think presumably to insulate doctors and care providers from the actions they do while saving somebody's life. So I don't know that the court has to answer the question, but the state doesn't concede that that type of justification would even apply here.
But let's presume that it does.
Okay.
Often, when we're presented with a claim that you should have sought justification instead of, accident or I wasn't there, we say, well, even if there was slight evidence to support it, such that the trial court would have been obligated to give it if you requested it, it clearly wasn't deficient because it's completely inconsistent with the defense you're trying to make, and it undercuts your better defense, and so, a reasonable lawyer wouldn't do that. It seems to me that framed the way that it's been framed here, it isn't inconsistent really at all with an accident theory. Like, those could peacefully coexist, right?
I wouldn't say they could peacefully coexist. You can always raise, as we learned from McClure and Pennington, it's never really a good idea, but you can raise a pair of defenses that are inconsistent with each other and let a jury decide.
Sure, but my question is, why were they actually inconsistent? I mean, it may
My-
be the justification didn't add a whole lot, but it's not, I was in fear for my life and I shot this guy while simultaneously trying to argue I wasn't there. It's, this was an accident and I was trying to save her life. Those do seem to overlap a fair bit.
So to directly answer the question, the fact that those overlap a little bit mean the justification wasn't the sole defense. So on the question of ineffective
So
assistance,
let's put the sole defense thing to the side for a
Okay.
second. Does this type of justification require criminality?
yes, and that's the other part of this question, of the equation here. Justification excuses criminal conduct when there's a really good reason for doing it. That, in plain English, that's what
Otherwise,
justification does.
criminal conduct becomes not criminal.
Exactly.
Under certain prescribed circumstances.
That's correct. Accident absolves conduct when there's no criminal intent at all. So,
So,
to,
yeah, so to get this defense, do you have to admit that you're doing something criminal?
well, it comes
For
into.
the purposes of the defense, at
For the
least.
purposes of the defense, I would suggest yes, despite McClure and Pennington,
I think that's a very hard position to maintain post-McClure.
which is exactly why I don't think the court actually has to get there, because they are two equally applicable defenses, which means it's not ineffective to choose one over the other. Again, separate but parallel tracks. However, I do think that at the end of the day, the choice that they made of an accident to pursue was something they were somewhat boxed into from Jennifer's initial statement to police. And so it's not unreasonable to put all of your eggs into that basket and pursue the accident theory, particularly because that's exactly what Jennifer always said is what happened. Notwithstanding the fact that there is absolutely no evidence in the record at all that the child was choking on a piece of chicken. There was nothing in the room, there was nothing in her throat, there was nothing in her stomach to support that that had any basis in fact, but that was the story they were stuck with. That's why Ms. Moll said that this was a ridiculous defense, but it was the defense she had, and it's not ineffective for her to pursue that. And
Good timing, Counsel.
thank you for your time.
Thank you both for the fine arguments. We will have you a decision as soon as possible. We will now stand adjourned until the next session of oral arguments in May.
All rise.